We will go ahead and get started, and want to welcome everyone to the House Judiciary Committee, our meeting this morning. We have 3 bills on the calendar, and just for planning purposes, I'd like to go ahead and tell everyone what to expect, or what we're expecting at this point. We're going to call House Bill 479 first and hear from a few witnesses before we hear from the sponsor. The other 2 remaining bills are very important matters, and what I would do is just ask the sponsors to maybe report back at about 10 a.m. on those bills, the sponsors and witnesses. That's House Bill 138 and House Bill 358. And all right, and so what we'll do is we will go ahead and call House Bill 479 at this time. I want to just begin, take a little chairman's time to give some of the history that really brought this issue to the forefront. It was approximately a year ago that we first heard about the killing of Ahmaud Arbery here at the state capitol, and that was through the release of the shocking videotape of his killing. And one of the first calls that I made at the time was to Marissa Dodson with the Southern Center for Human Rights to discuss what the citizen's arrest statute was and how exactly it applied, because frankly, I was surprised to know that there was such a statute when I first heard about it. And I think that the important discussion that we had last year around passing a hate crimes law in the state of Georgia being one of only 4 states without such a law at the time, I think was recognized as really part 1 of the action that needed to be taken. We needed to implement a hate crimes law in Georgia and then turn our attention to a repeal of the state citizens arrest law. And what we did is immediately after the session that we had in June of 2020, a working group began working on this issue. And I'm very grateful for the time that was put forward, because frankly, it was considerable. We had Marissa Dodson from the Southern Center for Human Rights, Reverend James Woodall from the NAACP. We also had Representative B. Wynn from the House of Representatives, and Sadie McIntyre, who's the granddaughter of former Representative Buddy Hardin. And we spent countless hours, a great deal of time working on passing this important legislation, working on what the proposal might look like. I'm also grateful for the members of the committee that I used to chair, which was the Judiciary Non-Civil Committee, because we actually had hearings last year. We had 2 different hearings to work to address that issue, the repeal of Georgia's citizens arrest law, which would be a real landmark change. Georgia would be the first state, one of the first states to do such a thing, to repeal the state citizens arrest law. I want to applaud Governor Kemp and his efforts and leadership to address this repeal this year, which we're going to have an opportunity to review through his floor leader, Chairman Burt Reeves, who's with us today. I do expect that we will need to give adequate time for review of any proposed language. And the governor's floor leader provided our committee with his substitute yesterday afternoon. Of course, we know crossover day is on Monday, but I expect that we're going to spend the time necessary to fully vet and review this proposal, as well as any proposed changes to the language. And so I'll look forward to that, and I appreciate and want to thank the committee members in advance for their time and dedication to do that. So what we'll do at this time is we will go ahead and begin with some of the witnesses, the advocates who have been working tirelessly on this issue for a great deal of time. And I'll first call Marissa Dodson, who is joining us virtually.
Good morning, Chairman Estration and members of the committee. Thank you again for the opportunity to present virtually this morning, and Chairman Estration for your longstanding commitment to this issue. My name again is Marissa McCall Dodson. I'm a lawyer and the public policy director at the Southern Center for Human Rights. As you may know, the Southern Center is a nonprofit organization working to promote equality, dignity, and justice for people in criminal legal systems in Georgia. It is because of our continued advocacy against state-sanctioned violence that we join in the call for Georgia's citizens arrest law to be repealed. As Chairman Estration said, just last week, we observed the 1-year anniversary of the killing of Ahmaud Arbery in Brunswick, Georgia. Because our citizens arrest statute was used to justify his death and delay justice, The Southern Center for Human Rights has been working with the NAACP, the Just Georgia Coalition, and state lawmakers, including Chairman Estration, Representative Dee Wynn, Representative William Bodie, and the sponsor, Vice Chairman Burt Reeves, to identify the most effective and responsible way to repeal this overly broad, unnecessary, and dangerous law. Georgia's current law allows any private person to conduct an arrest when any crime has been committed in their presence or immediate knowledge. The law also allows a private person to pursue someone if he or she has reasonable and probable grounds of suspicion that the person committed a felony offense. Finally, and probably most concerning, while the person making the arrest is required to take the person to a judge or a peace officer, the private person conducting the arrest can legally hold the person for up to 48 hours. While not codified in our law until 1863, citizen's arrest originated in medieval England as a creature of the common law and was developed during a period in history when law enforcement was not conducted in a uniform and organized manner. In the century since, law enforcement has been formalized and technology developed in a way that officers can quickly respond to requests for aid, making the authorization for private persons to arrest unnecessary. Today, every law enforcement officer authorized to conduct an arrest has received hundreds of hours of training and must be certified by the Peace Officer Standards Council. And yet, despite the substantial resources poured into their training and certification, law enforcement officers unfortunately still cause harm to civilians, and most often, unfortunately, people of color. If trained law enforcement officers can harm civilians during an arrest, despite rigorous training and testing, it is not only unreasonable to grant this authority to untrained persons, but also irresponsible. It is important to note that Georgia's citizen's arrest law is inextricably linked to this state's painful history of racial violence. According to historians and legal experts alike, the citizen's arrest law in this state and around the country has long been used to condone racial violence and mark a disturbing intersection of racist policing and anti-Black vigilantism. After slavery was formally abolished, the citizen's arrest law was used as a justification for white lynch mobs committing acts of violence against Black people in our state. This historical pattern, citizen's arrest being used as an excuse for the killing of Black people, has persisted into the 21st century with the deaths of Ahmaud Arbery last year and Kenneth Herring in Clayton County in 2019. While most people around our state and our country know about or have seen the tragic killing of Ahmaud Arbery, few are aware that the year before his death, another Black man, 63-year-old Kenneth Herring, was killed by another white person conducting a citizen's arrest. After seeing Mr. Herring drive away from the scene of a car accident that she was not involved in, Hannah Payne followed Mr. Herring, cut him off in traffic, demanded that he exit his vehicle, and fatally shot him. Now, some have pointed to the arrest of the killers of Mr. Arbery and Mr. Herring to defend the law, but people should remember that neither of these cases are final. Moreover, regardless of whether the defense holds up in either court, the results of the attempts to play cop remain the same. All three arresters now face multiple felony charges, and Mr. Arbery and Mr. Herring tragically lost their lives. I would now like to address 3 quick points regarding the detentions that are authorized by House Bill 479. The first is to clarify what entities will still be permitted to detain people in limited circumstances. We realized early on in our call for Georgia to repeal the citizen's arrest law that there were private persons who were routinely using the law to conduct brief detentions of persons while waiting on a law enforcement response. These entities most often include owners and employees of stores and restaurants, but also private security guards and weight inspectors for commercial vehicles. If House Bill 479 passes, these entities will continue to be allowed to conduct reasonable detentions in limited circumstances, but no private person will ever be able to conduct an arrest. Next, I'd like to correct some common misconceptions I want to make clear that there are no exceptions to the repeal of citizen's arrest in House Bill 479. Instead, the bill appropriately allows limited detention so that certain private persons can detain someone to contact law enforcement when they believe particular crimes have occurred. We don't want people to step into the shoes of officers and law enforcement. We want instead for people to call upon them when it's necessary. Perhaps the reason for this confusion about detention is because people believe that arrest is the same as a detention, that the differences are nominal, but this is just not true. Which brings me to my final point about clarifying the difference between arrest and detention. First, while it is true that an arrest is always a detention, A detention is not necessarily always an arrest. The distinction turns primarily on the length of time a person may be detained and the scope of the investigation that may follow the initial encounter. A detention is considered a brief and cursory hold, while an arrest is more indicative of the person being in governmental custody. For an arrest to be considered valid under the Fourth Amendment, the arrestor must have probable cause, whereas only a reasonable suspicion is required to conduct a detention. We believe that House Bill 479 strikes a good balance by limiting the encounters between private persons when there is a suspicion of criminal activity. Georgia will be keeping people on both sides of these encounters safe. Given the dangers of citizens arrest laws far outweigh their necessity in today's context, that's the historical reference in terms of what we spoke about how the law came to be in our state, and the fact that this law continues to be used to justify anti-Black violence, we support House Bill 479 and ask that you vote yes on this important bill. We think this bill will move Georgia in the right direction. I'm so grateful for the opportunity to be here, grateful for the leadership of Governor Kemp on this issue. Again, thank you, Chairman Estration and Vice Chairman Burt Reeves, for your leadership. I'd be happy to answer any questions.
Thank you very much, Ms. Dodson. Any questions from members of the committee? All right, seeing none. Thank you again for being with us here today. All right, what we'll do now is we will hear from Reverend James Woodall. If Reverend Woodall, if you'd please come forward and take a seat here in the witness chair, please. And also, I'm expecting that Dean Calvin Smyre will be coming by, and I told him because appropriations is starting at 9:30, we would get him in before committee. So if Dean Smyre comes by, we'll make sure to get to him. And here he is walking in the door. So, morning, Dean. Would you be willing to have a seat at this chair right up here with the microphone? What we'll do at this time, Reverend Woodall, would it be all right if we proceed with Dean Smyre? What we'll do is we have here today the governor's substitute to House Bill 479, which is LC 413070 ECS. There's also some later language which has come in. I don't want any of the committee members to be confused about which draft we're discussing or Ms. Dodson was referencing, but that's what's before you here. And finally, while we're on a break, it looks like we're out of chairs with microphones. So I noticed we've had a representative join or come in the room who's not a member of the committee. If he wouldn't mind watching virtually, that would be great. All other sponsors who have legislation with us here today are welcome to stay. All right. So at this point in time, I'll recognize Dean Calvin Smyre, who's the Dean of the Georgia General Assembly.
Thank you very much, Mr. Chairman. And let me say at the outset, I support the bill. I got a couple of points last night from staff that I read, and I have no problem with the additions that the governor has added. But my tenet is that, as you recall, last year when I worked with you and other members of the Democratic and Republican side of the aisle on the hate crime bill, I made a promise to Auburn Arbery's mother, Wanda Cooper Jones, that we would come back and pass and repeal citizens arrest law. And I promised a lot of advocates, and one is to my left, the president of the NAACP and others, that I would give everything that I could in passing a repeal of the citizens arrest law here in the state of Georgia. And every meeting that you and I met, in conference and otherwise, citizen arrest became a part of the subject matter, as you recall. And I just came here today just to follow up on that commitment and to give my my comments to that effect on the repeal of the citizens arrest law. It's a lot of implications. It's a lot of tenets that we've got to deal with it statutorily, and I'm gonna leave that to the lawyers. But the intent, and I want to express my intent and my sincere intent is to get the bill to the extent that we can get the members of the Georgia House to pass it and members of this committee, and then go from there. I know there's a wide scope of versions of the bill, and people have different aspects of it. And but as a person who has lived in Columbus and Georgia all my life, and one who has seen our state move forward, and to say that hate crime was a major step in that direction. And so that's my reason and rationale of wanting to come today, not to get into the aspect of the bill, but to come and to say to you and the committee and to the public that I'm doing all I can to make sure that we get this bill passed. So that's my only rationale for coming. I support it. I'm one of the signers of the bill, and I just want to come and add my support in that regard, in that respect.
I want to thank you, Dean. I want to thank you for being here today, for your comments, for your dedication and devotion to this issue and to justice in our state. And that goes far beyond your support and work on this bill. It's spanned the length of your career, and I'm grateful to have had the opportunity to work with you and consider you a friend. I'm very grateful to you.
And I want to add one other thing, Mr. Chairman, and I want to thank the various advocates, and there are plenty, and I want to express to them because a lot of the information that I receive and all of the technical aspects of the bill, I get that information, and it's good information, and it's something that I can absorb and be able to express in terms of the legislative aspect of it. And then the business community has been helpful as well. So I wanted to say that the Atlanta Chamber, the Georgia Chamber, and other chambers around the state of Georgia has expressed that as well. And my last comment is that I drove to Brunswick, Georgia, during the after the killing of Ahmaud Arbery, and talked to a lot of citizens down there, and that's still indelible in my mind. I still have my days I think about that. It was during COVID, and I thought that I went to bed not going, but I woke up going. It's just something in me to say, get in my car and drive down to Brunswick. And I did it, and it was an experience that I'll never forget. And I don't take it lightly for the General Assembly to pass it. It was major. And sometime our state has to make major steps in all that we do. And over my life here in the General Assembly, I've seen us take major steps. And hate crime was a major one. And I thank you all. And I've been in this room a few times, but whenever I've been in this room, justice has been served. And I look at the people in this room that I admire, because y'all do great work. People don't know the hours y'all spend in here. I look at Barry Fleming, I look at you, and I look at all y'all. You spend a lot of time in here. And I don't want it to go unnoticed. And that's why I want to come today, and just to say that.
Any questions for Dean Smyer? Thank you very much for being here, Dean. Thank you.
On the appropriation.
Thank you. Yes, sir. We'll now recognize Representative Reverend Woodall.
Thank you, Mr. Chair, and to the members of the committee. First, I want to just take a moment to thank this committee for taking up this very necessary legislation, as well as to the sponsor of this legislation, State Representative Bert Reeves, the vice chair of this committee. I want to first start by addressing the statute currently, and then go into the substitute that has been presented of 479. First, as it relates to the current citizens arrest provision requirements, The circumstances under which an arrest can be made is very problematic, but then second to the means through which that arresting actor is authorized to conduct that arrest is why this legislation is so necessary. Because as it currently stands, this provision creates four distinct problems that relates to the broad set of circumstances in which the statute would license an arrest. First, the term within his immediate knowledge authorizes an individual to determine whether an offense has been committed. Second, the citizen's arrest of suspected felons may take place before, during, or after the commission of a crime. And further, a private person does not need to be present at the scene of an alleged felony in order to apprehend a suspected felon, which is really at the heart of what we saw in the Ahmaud Arbery case. Third, the Georgia citizen arrest statute, it fails to distinguish between felonies that are immediate threats to public welfare and those that do not constitute a continuing immediate threat. Fourth, the statute 17-4-60 currently establishes that a private person may arrest him upon reasonable and probable grounds of suspicion, because it requires citizens who are largely untrained to evaluate available evidence. And so this creates additional public security or safety concerns. And then finally, the current statute conflates reasonable and probable cause standards, which further increase the risk of unlawful arrests. And so this section, its use of both reasonable and probable cause standards may compound that confusion for civilians who are unfamiliar with the difference between the two evidentiary thresholds. And so the other issue that arises in the current statute is why this legislation is necessary is because under the Open Records Act of Georgia, 50-18-70 subsection B2, Georgia's police agencies are required to release all public records that do not fall within an exception. But under Georgia law, there are no documentation requirements for police with regards to citizens' arrests. And so as a result, it appears likely that only the more extreme miscarriages of justice, i.e. the Ahmaud Arbery case, are purportedly justified as citizens' arrests and thus noted in evidence. There is no mention whatsoever of an attempted citizen's arrest in the police incident report documenting the murder of Ahmaud Arbery. And so with no accountability mechanisms under Georgia law, there's no way to record citizens' arrests, determine how often they are made, document or analyze the disparities in which they are used. And so to transition to the current legislation, there are just a few points I would like to make in which we want to highlight for this committee. One, as it relates to the repealing of citizens' arrest in its entirety. For those, there have been members who have said that this doesn't repeal citizens' arrest. And I would refer to section 2 of the bill that it says said title is further amended by repealing in its entirety Article 4 of Chapter 4 relating to arrest by private persons. Secondly, I want to briefly just go over the individuals who would be making detainments or allowing through law to be able to be to commit, detain, or to detain an individual as a private person. And there are 3 clarifications. We don't necessarily call them exceptions or carve-outs. They are clarifications of already existing code. One, an owner of a retail establishment who has reasonable grounds to believe that an individual has committed the offense or attempted to commit the offense of theft by shoplifting, refund fraud, or theft by unlawful use of retail sales receipts. 2, an owner of a food service establishment. The same goes for them, a weight inspector conducting his or her duties under such article. And then 3 or 4, a licensee or registrant under Chapter 38 of Title 43. Then we have, that's section 2, excuse me. Another part that I want to highlight is that the question around when this detention actually takes place, what happens? Because that's been another, point of emphasis for a lot of our folks in the advocacy community, is that currently under the code, there is not any guidance that tells what happens under that detention process. This legislation clarifies that and makes it available that an individual shall either release said individual or within a reasonable time and contact law enforcement. That guidance has not been clarified to this day. And so right now, this is an improvement on existing law. Thirdly, nothing in this legislation I want to highlight this very, very clearly. Nothing in this legislation shall be construed as limiting or altering self-defense statutes or stand your ground. That is not the intention of our advocacy on this piece of legislation. So I just wanted the committee to know that we are not in any way at this time trying to alter or limit self-defense claims. The last thing I want to mention, Mr. Chairman, and I'll be through, is that currently in code, there is no guidance as to whether or not deadly force can be used in a detention or an arrest. This legislation clarifies that in the process of committing a detention. As far as arrest, there are current laws and case law that would talk about that, so I won't go into that because I'm not a lawyer. But all in all, this is a good bill. We think this is good policy, and we think this will ultimately save lives of Georgians all throughout this state.
Thank you, Reverend Woodall. Any questions? Seeing no questions from members of the committee, thank you very much for being here. Call up Cosby Johnson at this time, please. Morning.
Morning.
Thank you for being with us here today.
No, thank you all. I want to say that most of the times I come before you all, and I don't come before this committee much because I try and stay away from the lawyers. I am representing the Georgia Chamber of Commerce, and today I will be representing the Georgia Chamber of Commerce in a way, but let me say that there is a reason that I do not have on my lobbyist badge, and that reason is because I'm also a citizen and a son and was born and raised in the city of Brunswick, Georgia. Thank you, Chairman Abstration and committee members, for your time and continued efforts to push through these unprecedented times and still seek to do the people's work. Words so often escape us. We grapple with the sorrow and numbing pain that comes basic to mankind. We try to understand both ways of happiness and grief, knowing that these things are simply a part of existing in the singular robe of humanity. For most of us, Sunday is the day where we lay these worries at the feet of a kinsman redeemer. It is on that day that prayers are exalted for the power to exist in the world so often stained by inequality. Sundays are for long dinners and conversations with families about how God is showing up and showing out in our lives in a world bent on stripping your soul down to the marrow. Sunday is where we often find a balm in Gilead, shade in the desert, rest for our weary soul, and water from a well that never runs dry. Like everything, Sunday, tragedy in its midst remains unconscionable. Like Birmingham on that September Monday, woken by the earth trembling on 16th Street, Brunswick lost far more than a life that Sunday. We lost a light, a future, a smile, an embrace, a friend, a ray of hope, a son, a shoulder to lean on, and a child of our city. On a Sunday with God's splendor draping the golden aisles, Ahmaud Arbery was murdered. Far too long and far too often, we have lost our generations to the seething discontent of others. It is this unmitigated disassociation from the notion that we are all one family, sewn together by a singular existence, that allows someone to follow, track, and murder a child of God. However, it is even more egregious that a justice system saw fit to excuse such malice with not only an antiquated law, but also with a racially ossified mindset. My generation now knows the blood-stained soil that bears strange fruit, and now more than ever, hold the seeds of injustice that sow action that sparked a peaceful protest that drew the eyes of a country, action that seen voters of Brunswick exercise their right to vote in historic numbers and send a DA derelict in her duties back home, action that echoed so deafening through the shores of Satilla that a governor signed into law a long overdue hate crime statute, action that reminds all of us in the face of such deliberate wrong, we can and we are called to do right. House Bill 479 represents that right. That right we must do to remove the vestiges of laws that continue to create, foster, and protect an atmosphere of hate, racism, and violence. What I've learned in my many years having the pleasure to work with so many of you is that oftentimes right is purely a matter of perspective, but sometimes Democrats and Republicans alike come together to do what is truly right. Sometimes a preacher from Atlanta and an old Southern Dixiecrat can work together to ensure the right to vote for all of our citizens. Sometimes an energetic governor named Zell Miller can work with a rapidly changing legislature on one accord to give hope to generations of Georgia's children. Today represents one of those rare sometimes you get as legislators to do something that is so clearly right, to begin to find ways, however small, to bind up those fissures that so easily beset us. House Bill 479 doesn't provide closure for Ahmaud's family. In the words of Reverend Al Williams, that can only be done by the great burden bearer and heavy load sharer. But House Bill 479 does say to Georgia that no longer will we allow antiquated laws to be used to justify the heinous act that we saw a mother and a father lose their hearts in an instant. House Bill 479 does say that we can stretch, even if just sometimes, to move that long arc of the moral universe ever so slightly towards justice. Thank you, Chairman Efstration, for your push on this. Thank you for your willingness and your push on the passage of hate crimes last year, a bill that you worked on so long before the murder of Ahmaud Arbery. Thank you, Chairman Reeves, for your leadership in this effort and your willingness to carry the torch through some tough legislative battles ahead. Thank you to Governor Kemp for his spearheading the legislative passage of this most important bill, but also thank you to the Brunswick and Glenn County community who has never stopped running. Thank you to the groups who helped shine a light, who called a legislator and build rallies through the city because COVID couldn't hold justice. Thank you to Marcus Aubrey, whose strength and love in the face of loss ignited a community. And thank you to Ms. Wanda Cooper Jones. Your tears rolled down like a mighty stream of justice and shook the consciousness of a nation. For all of those reasons and many more, myself and the Georgia Chamber would like to ask for this committee's deliberate, swift, and favorable consideration of House Bill 479. Thank you, Mr. Chairman.
Thank you, Mr. Johnson. Any questions from members of the committee? All right, hearing none. Thank you very much for being here today. What we'll do now is we will call up the sponsor, Representative Reeves, the governor's floor leader, and also with him today is Mr. Porter. Mr. Porter, you're welcome to stay near a microphone in case needed. While Representative Reeves is coming up, I will just take a point of personal privilege to thank Mr. Porter for being here today. Thank him for his service to the people of Gwinnett County and the state of Georgia for decades, and his great leadership on many, many issues. I remember my very first legislative session and having an opportunity to work with him in his capacity, leadership with the District Attorneys Association, Prosecuting Attorneys Council, and his leadership on this issue, willingness to weigh in and appear before the Judiciary Non-Civil Committee to offer testimony previously on this issue. So I just want to thank you, Mr. Porter, for your service to the state, and speak on behalf of the members of the committee. I think I can speak for everyone saying we are very grateful for your service and leadership to the state. Yes, sir. Yeah. We'll go ahead and proceed now with the governor's floor leader, Representative Reeves.
Thank you, Mr. Chairman, and members of the committee, and everybody who has a stake in this. And I don't quote Coach Kirby Smart very much. In fact, I don't think I ever have. But Coach Smart said a couple of years ago that pressure is a privilege, and getting involved with this legislation the magnitude of this has been overwhelming. The scale of this issue and the opportunity for Georgia to lead the nation in doing what's right has overwhelmed me. And it is a different kind of pressure than I've ever felt, but I want to acknowledge that it is a privilege to be able to sit here right now. And Chairman Efstration, I guess I kind of feel like a Braves relief pitcher that came in late in the game after Greg Maddux had pitched a perfect game. And you set this up and you worked on this issue, and you pitched the perfect game. And then I'm picked up where you were, and I just thank you for the work that you did on this, and really working with everyone to blaze this trail. And the first thing that I want to do for the committee, I know that we have only a few people in the room. I know there's folks online, but one of the, like a lot of complex issues that we deal with in the legislature, one of the most important things is understanding what something is and what something is not that we're considering here. And citizens arrest is a very different concept than the concept of self-defense. Citizens arrest is an offensive act. If you citizens arrest law says you see a crime happen and then you offensively engage in a citizens arrest of that person. Self-defense, while there might be some overlapping natures in certain conducts, self-defense is you perceive something that is happening to you, someone else, to your habitation, or to your property. And once that perception has taken place, it triggers certain rights that you have to act defensively in that. And so it's very important to understand out the gate that citizens arrest and self-defense are two very different concepts. But I think that what's happened here is there has been a massive effort, some of it, I think, innocently and some of it intentionally, to confuse the issues and to conflate them. Reverend Woodall went through the bill, but as the author, I just want to very briefly, this is actually a very relatively simple bill. Let's start in section 2. And this repeals code sections 17-4-60, 61, and 62, which is our current citizens arrest law. As Reverend Woodall said, and this is really derived through what we call jurisprudence and case law. There are certain common sense rights to detain that have been acknowledged through case law, and that acknowledgement through case law has been derived from the doctrine of citizens arrest, and that includes the ability for our loss prevention officers at our retail stores to detain potential shoplifters, and then the same thing with weight inspectors and private security, and also this other concept that's extremely important. When we do something like this, it's important that we act very deliberately and making sure that when we change one thing that we get right the other things that it stands to change down the line. And right now, police officers have limited jurisdiction, but case law has given us doctrine that demonstrates that police officers in certain limited circumstances have jurisdiction outside of where they are normally limited to. And that through case law it's derived from the concept of citizens arrest. So if we repeal citizens arrest, then we need to do what I call patchwork. And that's take these common sense rights to detain and in police officers limited rights to make arrests outside of jurisdiction and place them in other code sections, which is exactly what we've done in section 3 is a new code section 17-4-80. And this is what will offer the right for retail, for food service establishment, for weight inspectors, and for private security to be able to make reasonable detentions while the police are contacted. Then that leads us back to section 1, talking about our police powers and making out of jurisdiction arrests. If you go to page 3 in line 44, what this essentially does is it allows out of jurisdiction officers in limited circumstances to be able to make or engage in an arrest. And number one is if an offense is committed in such officer's presence or within their immediate knowledge. There's also case law that says a police officer is technically on duty 24 hours a day. They have a constant duty to protect. And derived from that and the concept of citizens arrest is birthed the idea that police officers, while they might just be at the mall shopping, but they see something happen, they have a duty and a right and arguably a duty to intervene. And A would cover that in code so that would continue. B deals with the concept of when a hot pursuit is taking place, that sometimes that crosses a city line or it crosses a county line. And that case law tells us that you don't have to stop at the county line. You can continue in that pursuit, make that stop, contact the local agency and detain that person while the local agency arrives. And then number 3 is, or C in line 53, is that you can you can always aid another officer out of jurisdiction who is engaged in an investigation or arrest. And then, so with this, there's been a couple of minor tweaks. The bill is 98% what was filed a few weeks ago. But one of the things that we did to make this a better bill was in number 2 and 44 through 47, we clarified that there are so many different kinds of law enforcement agencies in the state of Georgia, and they all have slightly different types of jurisdictions. For example, campus police officers are not allowed to make an investigation 500 yards outside of the campus. By law in Title 40, municipal police are required that they're not allowed to do that beyond the city limits. There are multiple types of other law enforcement agencies that are assigned to various government agencies like the Department of Revenue that don't have the same duties and obligations that other police officers do. And then there are some situations where folks like sheriffs have very unique duties that are different, that are frankly expanded from other officers. And so with that, in number 2, we added language that basically talks about the jurisdictional duties and limitations, so that we're not going to reference every code section that matches to every law enforcement agency, but we recognize that there are duties and limitations, and this code section is in conformity with that, so that it doesn't create a conflict in law. And then number 3 in lines 55 through 57 deals with the constitutional duties of a sheriff. Sheriffs have to serve warrants in other counties. They serve contempt orders. They have to comply with orders to apprehend when they pick up somebody that is a threat or harm to themselves. And this ensures that nothing in this code section can be read to limit that. The last part of the bill is section 7, which deals with tort liability. And this was a lot of this was cleanup on. There were changes that were made by striking certain aspects of citizens' arrest that required us to reconcile some of these issues as it relates to tort liability, so that we're clarifying, and essentially what the goal is for that to remain with this bill, and upon its passage into law, for those aspects to remain the same as they are today, but there was some cross-reference cleanup that was necessary there. That is the bill, and what I want to talk about, and I know that I think you've all received a letter from the Sheriff's Association, and I've tried to work very closely with the Sheriff's Association over the last few weeks, and there's 2 issues that they raise. Number 1 is that they talk about a section of the bill that potentially created a confusion about what jurisdictional rights are. And frankly, I added that section to the bill. At least initially, I thought it was upon their request, but then they stated that it had made things confusing. So I removed it. And so the first concern that's in the sheriff's letter has already been addressed. And the second concern is what I really want to talk about to this committee, if the chair will just allow me a minute to go through this.
Sure.
I don't know about each of you. I know that I have received a lot of emails, a lot of engagement from attorneys across the state who do not want to see this bill pass. And it all boils down to the concept of the conflation, like I spoke earlier, about citizens' arrest and self-defense. And I expect that each of my legislative colleagues have as well received countless hypotheticals in emails that talk about what it is that somebody can or can't do if they were to walk up upon a crime happening at their home, or to themselves, or to their spouse, or to their neighbor. And what I have been telling people from the beginning, and I have studied 16-3, 21, 22, and 23, and 24 are main self-defense statutes. And I have studied these exhaustively. I've read all the case law on citizens arrest. I've read a lot of the case law on these self-defense statutes. My goal when I became involved with this was to immerse myself in these concepts so that I understand them, well, and I can speak about them intelligently. And our self-defense statutes contemplate the right for private persons, anybody, to use reasonable force when defending ourselves, others, our habitation, and our property. And that concept of reasonable force, and I'm talking to a bunch of lawyers who understand the context of the word reasonable and why we use that word and why that word is important. But I acknowledge that it is harder to convey that to a layperson, that how we think of that word in the context of the legal world. And what I have been advocating and telling colleagues is that under the concept of reasonable force that self-defense allows us to use, that's a broad category that circumstantially can allow us to defend ourselves. And in some cases, reasonably defending ourselves in our property involves a detention. And there is a misinformation that is being, that there's a large effort to put misinformation out there that states that if we repeal citizens arrest law, then we are eliminating our ability to create a detention of somebody that has committed a crime against us. And in going through my case law, I came across a state, Robinson v. State, 270 Georgia Appeals 869. It's a 2004 Court of Appeals case. It's Judges Miller, Andrews, and now Justice Ellington. It's a great case because it's one of those cases, it's not even a page long, and as lawyers, we love these cases. But I just want to paraphrase what happens in this case. It's about a mailman, and a mailman gets a tip that his house is, that he needs to go check on his house. So he drives to his home, he pulls into his driveway, and he sees that the front door of his house is open. He goes around to the back door and goes in his house, and as soon as he gets to his living room, he encounters a burglar. That burglar has taken property of the mailman and has got it placed on the couch. The mailman looks at the burglar and tells him to freeze. The burglar then assaults the mailman in his home, pushes him down. The burglar then takes off running out the house, leaves the property. There's no longer a burglary being committed. He doesn't have any property that belongs to the man. So what happens next? The mailman runs out of his house chasing this individual. He actually gets into his mail truck, chases the individual 2 blocks by vehicle. The burglar then takes a left and runs into a yard. The mailman puts the car in park and proceeds on foot to chase the burglar, catches him, at which point the burglar assaulted him again, at which point the burglar now takes off and is now put himself into the mail truck and begins to drive away. The mailman chases the burglar down the street in the moving mail truck, is able to get into the mail truck, stops the vehicle, disengages it, pulls the man out of the car, out of the mail truck. And the case says uses an oak branch. I don't know if it's a big branch. I don't know. It doesn't say, but by using an oak branch, held that man until the police arrived. The Court of Appeals, in their analysis, very brief analysis, said that that was justified under 16-3, 23, and 24. There's no mention of citizen's arrest. This is not conduct that took place because somebody was engaging in a citizen's arrest. This is an example of reasonable force under circumstances. And the Court of Appeals said that his conduct was permitted. And I don't think that there's, I think that that's important because everybody out there that is choosing to take the most narrow interpretation of this bill and assume the doomsday scenarios that are being assumed. If you read this case, then this justifies everything that I have said. And further, 16-3-20, which is our justification statute in law, number 1 in this statute references our self-defense statutes, 16-3, 21, 23, 24, etc. If you read on down, number 6, in all other instances, which stand upon the same footing of reason and justice as those enumerated in this article. There's an even broader clause in justification that allows circumstances, allows a court, allows police officers, allows a prosecutor, allows a judge, and finally, if necessary, allows a jury to find that justification can occur. This idea that repealing citizens' arrest, which is emboldening citizens who are not trained police officers to go engage in inherently dangerous activity, is not the same thing as defending yourself. And the argument that has been presented on this is false, and it's not based on truth, and it's not based on what our laws stand for. I do not have any, I know that there's a substitute that,
No, it's not a substitute. It was just language that was submitted to the committee, which due to
Okay.
the last minute was distributed.
and
But
I don't know where this came from, and it doesn't matter, but I can tell you that this language does not repeal citizens' arrest. This doesn't solve the problem. The problem that it attempts to solve in this additional language is not a problem based on the analysis that I just gave everybody that's found in Georgia law and case law today. I would love to have Mr. Porter, 40 years experience as a prosecutor. Normally when he was down here, he spent his time in front of Judiciary non-civil. This is one of the most respectable people that I know. His insight, his ability to be fair, his knowledge of the law and how our laws work is immeasurable. The amount of time that he has spent testifying to committees in this body and has truly been able to move the needle on things. He's one of the people that I value the most down here. And he was engaged last summer with Chairman Efstration on this issue. And his input was so valuable that I asked him to come down here today. And if it's okay with the chair, can Mr. Porter?
Chairman Burchett has to run, so I'll recognize Chairman Burchett before he has to leave
Okay.
committee.
Thank you, Chairman Efstration and Chairman Reeves. I want to go on record as personally thanking Chairman Efstration for bringing or working on this tough issue, and also Chairman Reeves. I know that you've been visibly under the pressure of this piece of legislation. I think it's a very important measure. I think if we have any law on the books here in the state of Georgia that allows anybody to look at that video of that horrible action that took place last year, and find that it is there's a defense for that, then we must take a stance and make a change. So I want to personally thank you, and I appreciate the work you've done on this, and I'm in full support of this measure.
Thank you, Chairman. Recognize Mr. Porter.
Thank you, Mr. Chairman. And of course, I'll be happy to answer any questions that the committee might have. In listening to Chairman Reeves, I don't have anything to add to the testimony that's already been given, except I'm not sure that I'm not the author of some of this problem, because when I testified in the summer, I gave a historical purview of the citizens arrest law and its medieval roots and the lack of police organizations, and that's why it was necessary. And I basically said that it was no longer necessary. However, there had to be certain carve-outs to allow society to function, and those would include retail establishments, restaurants, where there's a detention of an individual who's suspected of a crime. And I also mentioned that, in my opinion, a homeowner with the wrong police or the wrong prosecutor might end up being subjected to a false imprisonment charge if they detained a burglar. I never really approached it from the way of habitation, because I thought it was cutting the needle or cutting the slice too thin. But what Chairman Reeves says makes absolute sense, that it's all a part of a continuing conduct. The stop, in other words, I catch the burglar, I stop the burglary. It only makes sense logically that I'm allowed to hold that person under that continuing concept of defensive habitation. So there are a number of ways that the actions of stopping a crime or intervening in a crime in progress would be allowed under our law. And I do think in 40 years of experience, I have never seen a citizen's arrest situation go well. Let me just put it that way. I gave an example in the summer, and I'll give another that involved a former assistant DA in Gwinnett County long before you were in the office and back when we were a small county. He believed that he saw someone shoplifting in a stereo store. So we had badges at the time, and he decided he was going to badge the person and detain them for this suspected shoplifting. And after he picked himself off the parking lot, it was discovered that the person wasn't shoplifting. And, you know, he opened our office, he opened the county up for incredible liability by making this sort of rash accusation and not only trying to make a citizen's arrest, but using the badge of authority to reinforce that, because DAs don't have arrest powers. We just don't. And, you know, I've just never seen it go well. Let me put it that way. So I think it's an unnecessary area of the law. It's an unnecessary, I don't want to say right, I want to say a power of a citizen to detain other citizens when law enforcement has progressed so far. And I think the exceptions that have been carved out solve all the problems, and I would urge support of the bill.
Fair to say, Mr. Porter, that citizens don't possess the training, education, experience that law enforcement officers have and really need to have in making determinations that would be the prerequisite to having those arrest powers. And along the lines of what you're describing, this statute is ripe for abuse or very bad outcomes. If
I think you're right, because most citizens receive no training in the force continuum that's allowed to be used with reasonable force to effect an arrest. The statute doesn't address it. It doesn't talk about what force can be used in certain circumstances, which gives a citizen more freedom than a police officer to resort to deadly force. Many of these cases where there's been an attempted arrest, there's also a use of deadly force, or at least a threat of the use of deadly force that would be unjustified by a police officer.
Mr. Reeves, am I correct in my understanding that Georgia would be the first state in the country to repeal a citizen's arrest law that's in statute?
That's my understanding, Mr. Chairman, and there's nothing that would make me happier than to see Georgia lead on this issue.
And along those lines, all 50 states currently have a form of citizen's arrest. That's a codification of the common law concept that we've covered.
That's my understanding. It originated in 1285 in England, I believe, and it was adopted. And at some point, it's been adopted by all of the states. But we're in a different time now. We have cell phones, we have 911, we have cars. We don't have a sole sheriff on a horse, and these inherently dangerous situations. There's different public policies, and our self-defense statutes clearly delineate some of those policies with protecting your house, protecting others. There's different levels of force that are permitted, but when it comes to somebody else's property or a situation that you don't know what's going on, and the prevailing public policy needs to be that we do not encourage those inherently dangerous situations, because as has been discussed, what could possibly go wrong, right? It goes wrong.
So just as I was reading the amendment, and both of your mics are live if you want to give input on this, but on line 94, I was going back to review OCGA 16.3 Article 2, which includes Section 22, I believe, is an immunity pursuant to, as a potential friendly amendment. How would you feel about at the end of the sentence writing defense or immunity?
Okay. Yes, I think that's a great clarification.
Okay. Which line is that? Be at the end of line 94, it'd be or immunity found. You know what? Not found. Let's just say or immunity, if that's agreeable.
That's a great clarification.
Mr. Porter, you okay with that?
That seems to clarify the statute.
Okay.
Yes, sir.
Prefer provided. Okay. All right. Representative Wilson.
Thank you, Mr. Chairman, and thank you, Floor Leader Reeves, for shepherding this through the committee. I want to thank you and the governor, and certainly Chairman Administration, for all of your work that you've done to get this bill here before us today. I think we can all agree that the time has come for this bill, and we've heard a lot about the Arbery case, and that certainly is a gross example of how the misuse of this current law, can result in the unnecessary death of Georgia citizens. But we know that that's not the only example of that. To DA Porter's comments, we know that there are other examples of this. So the time certainly has come, and I would like to see Georgia lead on this as well. Trying to be mindful of all the work that has gone into getting this bill here. I do have a friendly question for you. In that process, has there been discussion about adding a reporting requirement of some kind?
No, not with my involvement with the issue. I believe that may have been discussed in the past, but I have not been aware or engaged about that.
What, to the extent that we wanted to add a reporting requirement,
And let me ask, what would the reporting, if citizens arrest is repealed, then what would there be to report?
well, is there not, it is repealed, but is it not still, looking at starting at line 75, I think, there's still an opportunity for a private person to detain an individual.
And I mean, this
Right.
would be, say at any given target, there may be 10 people a day that are detained pursuant to loss prevention office, based on shoplifting activity. I'm not aware of anything that, obviously the reporting of this comes when they turn the person over to the police and a police report is created and a shoplifting case is made. I would say that if they choose to prosecute, then there's a report in that sense. But I don't know of any existing mechanism that requires reporting of that kind of data. I think that it could be, it could be burdensome because of especially these large retails, the number of instances that they face. But so I don't know the answer to your question.
Mr. Chairman, if I might pose a question to DA Porter about
Certainly.
maybe some educating of how that process plays out with a loss prevention team on site at a retail facility.
Now, it varies, to be clear, it varies from jurisdiction to jurisdiction. So I can only speak to Gwinnett County. In Gwinnett County, the Gwinnett County Police Department and the Gwinnett County Sheriff's Department have reached agreements with with all of the large retailers that basically once the detention is made for shoplifting, the police are notified immediately. The police then transport that individual to the jail, and there's a certain time period where the merchant has to come up and make a warrant application to establish the probable cause to commit the crime. So I agree with Mr. Reeves. In those cases where the criminal justice system comes in, there is a reporting mechanism in that the police reports are created. In Gwinnett, even if theoretically you could have a situation where a person was transported to the jail and the merchant doesn't show up, at that point they're released, but there's still a report. So there just wouldn't be a charge.
Okay. And Mr. Chairman, just to put a bow on this, Mr. Floor Leader, making sure I understand this bill correctly. Once we've repealed citizens arrest, we're still allowing for loss prevention detaining, correct? But other than or well, I guess loss prevention is shoplifting in a retail establishment or a food service establishment. But otherwise, there would be no other instance where
There's the weight inspector, and then the private security guards. And the reason why these were added is that these are individuals that currently have rights to detain under the concept of citizen's arrest. And these are the 4 situations that it is reasonable to believe and understand that there are proper times of why a detention would make sense. Imagine that weight inspectors don't do this much, but sometimes they look at a car and it's got a lot of bad stuff in it and they need to detain the person on the side of the road, on the interstate. And security industry is a regulated industry. There's training, there's requirements. There's a whole code section, the whole article about private security, and it's heavily regulated. And there are instances where, you have a private, some people have bodyguards and people are at threat, and there are instances where making a detention is appropriate. And so these were very carefully crafted and pulled out because there are public policy interests that demonstrate that these instances call for that. But we do not want private citizens untrained playing police officer.
All right, we have a question from Representative Bruce on Zoom.
I think my question was answered.
Yes, sir. Thank you. Any other questions on Zoom? All right, how about here in the room? Hearing none. So we have 2 other witnesses who are signed up, and I think that we are, we definitely have a busy agenda today, but I want to give anyone who wants to speak an opportunity. Christopher Bruce is here with us. Mr. Bruce, would you mind having a seat at number 4, please? We'll recognize you.
Yes, thank you, Mr. Chairman. Before I begin my remarks, I would just want to say, I used to intern in this room under Chairman Willard over a decade ago, so I won't say everything else. The things that he did to promote justice within this committee room, one, it hasn't changed at all, but within this committee room, it's one of the reasons why I'm here today. So thank you, Chairman Frustration, for continuing on that legacy of working towards justice. Thank you, Chairman Reeves. Thank you to the governor for weighing in on this issue, District Attorney Porter, everyone who's really taking a vested interest in this, righting wrongs that have happened in this state. I just want to go on record on behalf of our Executive Director, Andrea Young, the ACLU of Georgia, as the political director. These are the type of things that really instill faith within the process. So thank you. For my remarks with the committee, thank you, Representative Wilson, for your comments there as far as mandatory reporting. I know all of you have been part of previous committees where we talked about getting data from police departments and everything else to come together and come up with better policies. So I understand exactly where you're going with your questioning, Representative Wilson. Thank you for that. According to Georgia's law, which allows private persons to make arrests, was codified over 250 years ago. This law was enacted shortly after Georgia seceded from the Union and was fighting to preserve slavery during the Civil War. It was enacted to give greater power to other individuals who were acting as lynch mobs or slave patrols. And today it continues to permit for people to weaponize their own racial biases and deprive innocent Georgians of their most basic liberties, the freedom of life, which was saw with the horrendous murder of Ahmaud Arbery. We are grateful to the bill sponsors for putting this forth, a full repeal of Georgia citizens arrest law, and we hope this committee will see the great benefit of a full repeal as well. along with the full repeal of citizens arrest. The bill also makes an important change to the law by permitting certain individuals to effectuate detainments instead of arrests. The legal distinction between arrest and detain is an important one. To detain is to prevent from proceeding, while to arrest is to use the legal authority to deprive a person of their freedom. Another important distinction between the two terms are the legal consequences between an arrest, which has graver legal consequences than detainment. The standard to effectuate a detainment is also lower than to effectuate an arrest. In the years since Ahmaud Arbery's murder, his family and the Brunswick community have demonstrated great strength in their perseverance at this time. The community came together to oust the dishonest and dangerous district attorney. They came together to elect a new district attorney who is committed to righting the wrongs within that community. The community has been pushing for much needed law enforcement reform, and just a few weeks ago, the efforts of Ahmaud's family and the Brunswick community led to the introduction of House Bill 479 and the committee that we're hearing today. The ACLU of Georgia supports House Bill 479 because it fully repeals the antiquated, racist, and dangerous citizens arrest law in Georgia. We believe it is in the best interest of the state and all Georgians to remove the ability for any private citizen to conduct an arrest. So in closing, for the constitutional promise of we the people to truly mean all people, we must dismantle and revise laws that contribute to systemic racism that are overall harmful and unnecessary. HB 479 is a step in the right direction. We must act now to ensure nothing like Ahmaud Arbery's murder ever happens again in our great state. And I also want to make a recommendation as well, or a comment. What you said, Chairman Reeves, as far as distinguishing the case law and the things that have happened since, this will still ensure that Georgians are protected and still have the rights to protect themselves too. So thank you for pointing that out. We need to make sure that there's no misinformation out there as far as us moving forward towards justice. Thank you, Mr. Chairman. I yield.
Thank you, Mr. Bruce. Any questions for Mr. Bruce? Thank you very much for being here. We have one additional witness who has signed up, Jalen Furby, who's here in person. Madison, would you mind asking? Good morning. Yes, if you wouldn't mind having a seat here at microphone number 4, the committee would like to hear anything that you have to say. And you're welcome to wear your mask or remove your mask while you're speaking into the microphone, your choice.
Good morning, Chairman Efstration.
Good morning.
Thank you for hearing me today. Good morning, members of the Judiciary Committee. This is my first time speaking at this committee. I can tell that it's very formal. I also would like to thank Representative Misha Maynard, who's answered the call of duty after Representative Mabel Abel retired, and thank her office for supplying us with the information on this time frame for this meeting this morning. A little bit about me. I'm the founder of American Kinetics. I'm also a co-founder of Street Peace America.
Ms.
And
Furby, I'm sorry to interrupt you, but I had you down to speak on Bill 479. Are you here to speak on Representative Maynard's bill?
I am. I'm here for 479.
Yes, ma'am. Okay. Thank you.
And I wanted to say that I'm a Gulf War veteran. I'm a former police officer, and everything that I'm sharing with you about my accolades and my experience is not to showboat. It's only to lend credibility to my testimony here before you in support of passing this and also in support of Georgia moving forward. Like I stated, I'm a former police officer. I'm a Gulf War veteran. I attended the University of New Mexico and studied industrial security. I have extensive experience with policing and from both aspects, from having family members who've been arrested. And I want to talk about lines 44 through 57. As a former police officer and being in favor of this bill, I think that it's very important to note that this is actually giving more opportunities for policing in the community, specifically the line where it states that a police officer can make an arrest outside of their jurisdiction. I think that makes us more safe as Georgians. So often you have police who live in your apartment community. We know who the policemen are. We interact with them. It would be great to know that a police officer who's living in Buckhead or living in a building near me, but maybe serving the residents of Gwinnett or Macon, would have the ability to detain a criminal or protect citizens. So I'm in favor of this. I don't see it limiting anything in the community. I just see it as taking Georgia forward. I also want to speak to the history of Georgia. Okay, Georgia is the laws in Georgia were created when Georgia was a penal state. Okay, so the laws are already just a little different than some other states. And I think that this is a good opportunity to take it further, protect lives. We spent the summer marching so that the families that have been affected and lost loved ones could feel comfort that once this session opened, that we would see real change. This is the change that we're talking about. This is it. So there shouldn't be any, you know, across the board waffling. I'm a pro-Black Republican, and I'm here in favor of this bill. Please get this out of committee so that it has a chance. That's all I want to say. Thank you so much, Chairman.
Thank you so much for being here, Ms. Kirby. I know that you're signed
And
up
it's
on another.
Furby, F-U-R-B-Y.
I'm so sorry. Ms. Furby, you're welcome. I know you're signed up on another bill. You're welcome to remain in here if you want, or in the hall, just whatever's comfortable for you.
Thank you so much,
Any
Chairman.
questions for Ms. Furby?
Thank you.
Thank you so much for being here, and thank you for your service to our country.
Thank you guys for your service during a pandemic and coming to the Capitol every day to service the residents of Georgia. We're here to support our legislators. When you create a opportunity like this to change and move our state forward, I feel it our duty to be here to support you.
Thank you.
So thank you.
Thank you, man. All right, we will now, the committee will now consider the legislation that's before us. Okay, who is that? Ms. Chapman, I had you down for House Bill 138. Would you like to speak to this bill as well? Please come forward. Thank you for being with us here today.
Thank you, sir. So, first of all, hello, my name is Stephen Chapman. So thank you, Chairman Efstration and members of the Judiciary Committee for having me here and hearing me. I just want to speak on the credibility of a citizen's arrest. Let me tell you about myself. I run ATL Access Media marketing company here in Atlanta, and I see a lot of things in the community. I covered Brunswick. I've covered a lot of things here in Atlanta. And in my 40 years of living, I haven't seen a citizen's arrest per se, but the things that went on in Brunswick and the things that I've seen in the community doesn't bode well for citizen's arrest. I think it'll be too much, I guess you could say, hostility going on from both sides, that it wouldn't be, it isn't something that the community will flourish off of. I think it will hinder a lot of things. If this bill is pushed through, I think it will help to amend the already civil arrests that's going on now. And, you know, with the racial tensions and the way things is in America right now, we need to repeal some of these laws in Georgia. And this one is, if this one's is the first one that I'm a part of and I can testify to, I want to do that and be here, because it's important that you hear the voices of the citizens. That, you know, I may be walking down the street in my hoodie because it's cold, but some guy think I'm a robber, and I don't want nobody drawing down on me. And if they do draw down on me, at least it'll be someone who's trained, like the police, on somebody that has law-abiding motives in their mind, instead of a citizen who just may be biased. So we saw Trayvon Martin go through things like that. We saw over the television. One of my good friends, Joe McKnight, that played football for the New Jersey Jets, he got killed in a road rage accident. and they let the guy go home. So it's like, you know, we don't want that here in Georgia, and we want to focus on the citizens and pay attention to the citizens, because just because they poor or just because they displaced, that don't mean they're bad, you know. So let's just work on each other as a person and let the law be the law, and not people out trying to be cowboys and Indians, because it'll turn into the Wild Wild West if you do that.
Mr. Chapman, I want to thank you for your time, your willingness to testify on this bill, and I know you're signed up to speak on another bill later. But thank you so much for being here today. Any questions for Mr. Chapman? Hearing none. Thank you, sir.
Thank you.
So at this point, the bill is before the committee. Are there any motions? And you know what? We do also have Representative Gilliard, who is here today. And I had asked Representative Gilliard if he was willing and interested, if he wanted to provide any testimony or comments on this legislation. Representative, is there anything that you want to add, or would you like to testify to the committee?
Mr. Chairman, I'm fine. I want to thank you and thank all that Chairman Bert Reeves and yourself and the committee for doing an outstanding job.
Would you mind moving up to a microphone, just because we have many members who are online? Oh, yes, sir. That's perfect. What is the number that you have, Representative?
That is number 12.
Yes, sir. All right. We'll recognize Representative Gilliard.
Let me reiterate again, Mr. Chairman, and all that are great members of this great committee, especially my good friend, Chairman Bert Reeves. This is a historic opportunity. In the state of New York, Senator Michael Janarius, because of our actions and working together as a coalition to move Georgia forward, has now dropped the bill to repeal the citizen arrest law in New York. Representative Wendell Gilliard in South Carolina has now dropped the bill to repeal South Carolina's citizen arrest. So this work that you've done is stellar. The coalition, from the NAACP to the ACLU to the Urban League, you've done everything right in including the citizens of Georgia, law enforcement and citizens. So I commend you. I support it 100%. And thank you and the governor for moving Georgia forward.
Thank you very much, Representative Gilliard. Any questions for Representative Gilliard? Thank you for being here today. So according to my sheet, we have heard from all witnesses who were present and signed up to speak today. At this point in time, I'll hear a motion. There's a motion do pass from Representative Wilson, a second from Representative Oliver. All right, any discussion? So I have just a housekeeping amendment, which is on line 94. And what I'd propose, Representative Reeves, as a friendly amendment is after the word any, insert immunity or. All right, so that's the chair's amendment. Is there a second? All right. Any objection to the Abstration amendment? All right. Hearing none, it's adopted. Okay. All right. Any further discussion of the legislation? Any members online? All right. Very good. Well, we're now in a position to consider the substitute. So there's a motion and second on House Bill 479 LC 413070 ECS by committee substitute, as a substitute issued in committee here today. All those in favor signify by saying aye.
Aye.
Any opposed? All right, the bill passes unanimously. It's on to rules. Thank you very much, Representative.
Thank you, Mr. Chairman, and thank you very much, committee and everybody that was here today. Thank you. Thank you.
Thank you again, Mr. Porter, for being here today. An honor to have you.
Thank you.
All right, I'm going to call up Representative Setzler at this time because we have several witnesses signed up on 138, and that may take a while longer. So, Chairman Setzler, if you will come on up to the witness seat, we will get started with your bill. All right, so we have House Bill 358. This is LC 413074S, which is the committee substitute before us. And Chairman Setzler will begin when you're ready.
Thank you, Mr. Chairman, the members of the committee. Appreciate the Scoggins Subcommittee hearing this. And since then, I've worked with the chair and council to refine some language to simplify and clarify a couple of provisions in the substitute you have before you, LC 413074S. HB 358 is I think, a very important proposition, and it gets to this issue of balance of powers. What is the appropriate balance between legislative input, consent, and the vitally important role of a governor in effectuating the emergency powers contemplated in our state constitution, fleshed out in law, and what does that balance look like? What HB 358 seeks to address is some issues raised by members of our legislature that many legislators before 2020 believed existed generally, but because we'd never been in one of these states of emergency, came to recognize that the balance they thought was likely in statute was not. And this HB 358 seeks to address that. Mr. Chairman, would you want me to walk through the provisions in
Yes, sir.
detail or just, okay?
Well, maybe if you would just give us an overview, certainly of the concepts, and the members it's a short bill, so members can read the specific language. And if they have any questions about specifics, they can ask you.
Thank you, Mr. Chairman. What HB 358 does, and the substitute does not change any of the core concepts at all from subcommittee, but our language changes to make it more clear. It creates a structure where the governor's emergency powers, for example, for states of public health emergency, the legislature has to come in on the second day after the declaration and then concur or not concur. What this does do, it creates sort of a balance. It gives the governor 30 days of emergency powers, which without consent of the General Assembly, because many of the emergencies we face require some amount of time, but ensures that after 30 days, the General Assembly, for it to extend beyond 30 days, would have to concur with concurrent resolution. But then in concurring that it go beyond 30 days, any extension of that would be on 90-day periods that would terminate date certain after 90 days. So we can extend it 90 days, but each successive 90-day period of an emergency declaration would need to be extended with the consent of the General Assembly, so that the governor has 30 days of emergency powers. To extend beyond 30 days, the General Assembly would have to act and could extend it 90. And then any number of extensions of 90 days in succession would be authorized, but it would require that the General Assembly to rule and by concurring resolution to authorize that. And then secondly, Mr. Chairman, the other piece is the issue arose earlier this year when we were looking at this. Given the vastness of gubernatorial power under emergency declarations, that candidly contemplates anything from a dirty bomb to a pandemic to an outbreak of violence to acts of nature and hurricanes and tornadoes is so broad and so vast, as it needs to be, given the possibilities. This also allows the legislature to act in that concurring resolution to constrain as appropriate the powers of the governor in a way that's more appropriate with a disaster that's at hand. And again, so the General Assembly in giving this consent could constrain in appropriate ways, and in ways candidly many members believe that we had, but don't have without HB 358 to provide appropriate limitations so the governor can execute his powers and not having to consult again and again with the General Assembly, but just within a broad sphere set forth by the legislature. That's what the bill does.
Finally, what was discussed in subcommittee is the Bruce language that's included. Is Representative Bruce raised the possibility of meeting remotely, and that's covered lines 185 to 188, which would permit such a meting if part of the call.
Yes, a very important part of this bill that we would be able to, just as we've been functioning remotely in committees and those kind of, if there was a need to be virtual, that would, it's clarified in law that would be possible.
Any questions for Chairman Setzler? We, due to time, we've moved this up from the Scoggins subcommittee, but I'll just give Chairman Scoggins anything you want to add.
No, I just want to thank Chairman Setzler for bringing this bill. I think it's a great bill. And at the proper time, I'll be glad to make a motion.
Thank you. Representative Leverett.
Thank you, Mr. Chairman. I had a quick question. So as I understand, the governor could declare a state of emergency for 30 days. He couldn't go beyond that, but he could call a special session to obtain authorization from the General Assembly to extend it for up to 90 days or successive 90-day periods if the General Assembly were to authorize that.
That's correct. And what the governor, upon calling a state of emergency, could have 30 days without the General Assembly being engaged. He could call us in at any time prior to day 30, day 2, day 5, day 10, day 14. Perhaps depending on how things emerge on the ground, he would have some flexibility. But if he weren't to call us in, it clarifies that on day 30 at 10 a.m. in the morning, we would convene to consider this issue of extending it. Again, the goal is not to shut down the governor, but the goal is just to provide, if there's an extension beyond a month, that the General Assembly ought to be able to consider that. It could be 60 days or 90 days. Right now, it says, for example, for public health states of emergency, we shall come in on day 2. We're actually giving the governor some flexibility here. He gets sort of 30 days, really, as it were, as a freebie without advice
Yes.
from the General Assembly. So I think there's a real advantage to the executive branch in that way. But that for extensions, it does clarify this issue of a 90-day termination. Currently, the structure is the General Assembly could call itself into session, but that really takes there's a lot of process in that. There's things that can kind of interdict that process. If one of the presiding officers didn't agree with that, it requires a supermajority to actually get us into session. So this creates a date certain of 90 days that would terminate, that we could extend any number of times.
And then the General Assembly could also impose limitations or conditions on the terms of that declaration.
That's correct
as well.
And I think it's a very important thing. Again, if we have a disaster that's limited to some kind of incursion or some kind of even an act of nature, perhaps the governor's powers ought to be something less than the broad, almost very narrowly limited powers. It might need to be extended for a period of time, but the governor having the ability to seize property and some of those things that are contemplated might not be appropriate to the nature. So it gives us some ability to constrain that.
Thank you. Thank you, Mr. Chairman.
All right, very good. Any other questions for the sponsor? All right, hearing none. Chairman Scoggins made a motion. What's your motion, sir?
Pass.
Motion do pass from Chairman Scoggins. Is there a second?
Second.
Thank you. Motion is second. Thank you, Representative Dreyer. All right, any amendments or discussion? Hearing none, we'll call the question on House Bill 358, Committee Substitute LC 413074S. All those in favor signify by saying aye.
Aye.
Any opposed? All right, the motion carries. It's on to rules.
Thank you, Mr. Chairman.
Thank you, Chairman. All right, we will next call up Representative Maynor to present House Bill 138, Substitute LC 413058S. And please proceed whenever you're ready. Thank you so much for being here today.
Good morning. What a eventful and historic morning we've had so far. Thank you, Chairman Evstration, for the opportunity to present House Bill 138 before this distinguished panel today. It is listed as LC 413058S. This bill birthed on Thanksgiving Eve when families are enjoying each other, preparing turkeys and fixings for the next day, and celebrating the holiday season. This past Thanksgiving, a 15-year-old girl was nearly attacked by a naked man that was watching her take a shower at the pool lounge of an apartment building in Midtown, which is located in my district. It was a horrific event with failed 911 calls and the mother subsequently calling the sheriff's department for help. As a concerned parent, not only for her children, but all of the children that lived in this community, the mother asked the apartment complex to notify the other residents, but they refused. The mother then took it upon herself to notify other parents of the security loopholes, and the apartment complex retaliated against her and terminated her lease unexpectedly before the lease termination date. The crime committed that day is recorded as a peeping Tom violation, since thankfully no contact was made. This bill helps protect families like this. The average rent in this Midtown high-rise where the 15-year-old girl lived averages about $2,500 a month. You may say, why in the heck would someone pay $2,500 a month to live in an apartment? The answer is safety. The apartment complex promised this family safety and then retaliated against the family for trying to protect other children that use the same shower area. Crimes in apartment complexes affect people from all socioeconomic backgrounds and across all demographics. In cities across the nation, crime has skyrocketed. And when you think you are moving to a safe community, right now an average citizen would have to figure out the bureaucracy of the Georgia Open Records Act, which members of the committee stated during the subcommittee hearing is challenging and sometimes ineffectual. House Bill 138 gives everyday people, neighbors, community organizations, and landlords the ability to monitor serious crimes in their communities. This bill is proactive and is prevention oriented. It costs victims and landlords more to not have this bill, and for victims, the cost could be their lives. Today, I pray you yes vote, make a yes vote in particular for this preventive policing measure. Your yes vote for House Bill 138 could save a life, prevent a rape, stop a peeping Tom from watching a child while they shower, prevent sex traffickers from choosing ideal places to violate the law, or even prevent a senior citizen from innocently being shot and killed by gang members known to occupy certain dwellings. Your yes vote puts data into the community's hands. The crimes that would be required to post are murder, assault, battery, aggravated assault, aggravated battery, rape, peeping Tom, gang crimes, and felony drug crimes. This version of House Bill 138 evolved from its original version to accommodate and compromise with all stakeholders, including landlords, renters, municipalities, and law enforcement agencies. Originally, landlords were required to provide tenants the data and be fined as a result of not providing the data to tenants. This was removed. In subcommittee, as stated before, there was challenges with the Georgia Open Records Act. This resolves that challenge. Attorney Hollingsworth, the lawyer for the 15-year-old peeping Tom victim, will testify shortly to why he believes this bill can help countless other people and is a great preventive measure to decrease crimes. Yesterday, the former police chief of Gwinnett County and the current executive director of the Georgia Police Chiefs Association, Mr. Butch Ayers told me 3 important points I want to mention to you today. I'm thankful that I ran into him, but it's also sad to say that he's not here today because of a slain officer in Bainbridge, Georgia, Captain Justin William Bedwell, that died through senseless acts of gun violence. The significant points I want to mention from Mr. Ayers: 1, this is not a cost burden to law enforcement. It is a crime prevention measure. The more information that is readily available to the public about crime, the more crimes are prevented. 2, Mr. Ayers' own daughter was looking for an apartment in Atlanta. He was thankful that the Atlanta Police Department has data online for him to search and see what was the safest community for his daughter to live in. 3, after working with the Gwinnett County Police Department for approximately 30 years and nearly 5 years as the chief of police for Gwinnett County, He was nothing but complimentary about the voluntary crime-free multi-housing program that Gwinnett County uses to fight crime, specifically in apartment complexes. The crime-free multi-housing program shows that access to crime data helps tenants, owners, and the managers of rental property keep drugs and other illegal activity off of their property. It is a solution-oriented way to help the stakeholders and designed to be easy yet effective in reducing the incidence of crime on rental property. You have a description in a packet that should be on your desk about the program. This is a national program that Gwinnett County voluntarily uses. The takeaway from the crime-free multi-housing program in House Bill 138 is twofold. Voting yes protects victims, whether they live in a housing authority or they pay $2,500 a month. Gwinnett County is only one of 159 counties. Atlanta is one of 535 cities that are proactively using access to crime data to prevent crimes and save lives. That is in no way saying others are not. Sandy Springs is also doing it. According to Gwinnett County's website, some properties saw a reduction of crime up to 70% once they implemented this program. Who does this bill help? If you are a parent to a college student or recent graduate, you can use data from this bill to make sure your child is choosing a community that is safe. Displaying crime data online can increase property values because landlords will become more vigilant in its safety practices. Or it could actually cause a reduction in property values, particularly when the crimes begin to affect the reputation of the neighborhood. But if landlords seriously consider the crimes occurring on their properties and begin to use more preventive safety measures, they can potentially see a reduction in their maintenance and repair costs that result in crimes or excessive police raids. Last, I'd just like to say that I also spoke to a member of the Georgia Association of Housing and Redevelopment Authority, Mr. John Maria, with the Cairo Housing Authority in Grady County. He supports the bill because if criminals know that landlords are actively monitoring crime through police data, criminals will less likely do crimes in his buildings and will also less likely attempt to be a renter in those properties. The Housing Authority in particular mentioned the importance of keeping children safe on their properties. To end, this bill has changed dramatically since its original version, but today you can vote for victims, parents, law enforcement that enter into crime-ridden apartments, property owners, communities, children, victims of sex trafficking, rape, and all the sort. You also protect landlords because now they can readily access this information they didn't have access to before. Thank you.
Thank you, Representative. Any questions for Representative Maynard? All right, we have a few witnesses signed up. Representative, you're welcome to stay where you are if you'd like, just in case you want to respond to any witnesses. We'll first hear from Mr. Hollingsworth, who is online.
Good morning, and thank you, Mr. Chairman, and for the committee for allowing me to speak on behalf of the bill. My name is Matt Hollingsworth. I'm a personal injury attorney here in Atlanta, and I'm testifying in support of this bill in my capacity as a victim rights attorney and as an attorney who handles negligent security cases. I know that there were members of the subcommittee that handled these types of cases as well, but I wanted to offer my thoughts. I'm in support of this bill as an effort to reduce crime and to protect tenants. This bill will eliminate the bureaucratic red tape and allow at a local level for landlords, tenants, and attorneys to get this kind of information as both a preventive measure and as a measure after the fact. I had written a letter on behalf of this bill for the Judiciary Subcommittee hearing. I think it's a good idea for landlords to be proactive in notifying tenants. However, given the new writing of the bill, I still think this has a very positive benefit. My firm supports this bill as a strong measure for victims, but also for the landlords. Landlords have access to this information. They can be proactive in crime prevention, and they can leverage this information to provide a more complete picture of their potential tenants or Also, it allows the tenants themselves to do their due diligence before making a decision on where to move. The case that hits closely to this issue is what Representative Maynor mentioned in her opening statement. And I'm the attorney representing the 15-year-old girl who was attacked in the apartment complex. As she discussed, Representative Maynor, this young girl was attacked by a naked man in a very nice, seemingly safe apartment complex. And an important thing to note about that case is that the young girl's mother didn't choose that apartment complex because of the pool or because of the amenities. She chose it for safety. She specifically chose that apartment community for safety. She'd expressed safety concerns to management, and she had relied on their assurances when choosing where to move her family. A bill providing transparency, like Bill 138, would have allowed an additional resource for her to confirm that she was moving her family into a safe environment. The key here is that a bill like this would potentially prevent this incident from ever happening. It's to help victims and individuals choose the safest home for their families. If apartment communities have access to this information along with tenants, we can avoid these kinds of incidents. We're hoping to bring light to this issue so that landlords and tenants can prevent these from happening again, reducing the victims' injuries and likelihood of that, and also the landlord's liability. Landlords and tenants need to know who's living under their roofs, and they need to know their neighbors. Regardless of this bill, it's the apartment's complex responsibility to know who is leasing their units and having the information readily available to help them take the necessary precautions to protect the people they house. And I believe that, and our firm believes that this would lead to a drastic reduction in negligent security matters in terms of injuries on apartment communities, and it would hold a higher standard for the landlords and again for the tenants to be able to do their own due diligence. And I thank you for your time.
Thank you. Any questions for Mr. Hollingsworth? Hearing none. Thank you very much for being here today. If
Thank you, Mr.
Madison,
Chairman.
if you would please ask Jalen Furby and Stephen Chapman to come back in and take a seat. Yes, sir.
Feedback or anything from the Sheriff's Association or GMA or anything about them being required to keep a ongoing tabulation of anything? Did you ever hear anything from them?
So I did hear from GMA, and we tried to work out some compromises, and they preferred not to do any compromises.
Okay.
So they have no input from.
We're going to hear from GMA
Okay.
also in just a moment.
The Sheriff's Association, did you hear from them?
So I just spoke to the Georgia Police Chiefs.
Okay.
I did speak to Sheriff Patrick Labatt with Fulton County, and Patrick Labatt, Sheriff Labatt, I should say, referred me to the Atlanta Police Department interim chief.
Okay, thank you.
Mr. Chapman. Yes, sir. If you'd like to, understand you want to testify to House Bill 138.
Yes. Okay, my name is Stephen Chapman once again. I want to testify on House Bill 38 because I'm also a renter in the city, and I'm also looking for housing as well to buy. And I've ran across a lot of things when it comes to apartment complexes that they do not tell you, that they do not inform you of. And once you get into these places, then you hear the chatter from around of, you know, what type of place you're living in. I think it should be some mandates of more than just the glitz and glamour on websites, but really to tell what's that community about. Maybe like a Yelp about apartments. There need to be some kind of legislation to where apartments have to tell you whether, you know, there's crime going on there, pedophiles or whatnot. And to know that this is a safe place for my kids to come raise my kids and for them to go to school. It's important that I know that a lot of the redlining went on in the early days and pushed a lot of people into these apartment complexes. And there was in lied that was a bed of crime and things of that nature. So I know the police have their hands full dealing with these apartment complexes and these units of multiple people. But I believe that the apartment complex need to make sure that every resident is safe and feels safe living in those establishments, whether it be from, mold. I see a lot of painted over mold in apartment complexes. It's like, it's not, the tenants are not, priority. They just want some money, or they just want to be, what I'm saying, ignoring the tenants. And I have lived in those type of environments where the apartment complex has no, care for you in itself. So with that said, I support House Bill 138 and, and Miss Minor and her endeavors in our community, because it is needed.
Ms. Furby.
Again, Chairman F. and the members of the Judiciary Committee, I'd like to thank you for hearing us and also for your service to the residents in the state of Georgia. I'm here in support of HB 138 moving out of committee. I know my last testimony wasn't kind of heartfelt. It was direct to the point and more along the lines of the legalities. But in this case, I'm going to speak as a mother and as a member of the community and as a renting person who has experienced homelessness, as a citizen who put forth the Georgia Homeless Day and the Atlanta Homeless Day here in this Georgia state capitol. That summit takes place. So I have been a vested person who've had to look for housing. I'm recently coming out of homelessness myself and dealing with Atlanta Buckhead Far Road apartment community complex managers who are not only pleasantly mean and pleasantly tell you lies about what's happening on the property. They will look you in the face and completely lie to you. My brother, who's in building, said it best to me this morning. These major apartments do not care about the residents. They only care about getting your money. And because they're major corporations, guess what? They'll break the law knowingly because they'll think that residents do not have an out. Now, here we have this bill that's saying that they have to disclose what's happening on their properties, and it's going to shine a flashlight on all the inconsistencies and security issues that they may have in place. They may have lobbyists and people with big monies coming down here to tell you, put an end to this. We don't want to see this. But I can tell you, for people who are paying upwards of $3,000 per month to live in the city of Atlanta and other areas of this city, we deserve to know what's going on the grounds. In the community where I live, you can Google this, over 200 cars were broken into. 200. We have weird people who walk throughout the night. We don't know if they've committed crimes and gotten out of a state penitentiary. We don't know if we hear screams. When I lived on 17th Street, we heard some screams one night. We learned that someone was shot in their apartment and then drove down the 17th Street bridge, and the other person collapsed on the wheel of their car, causing a car accident. The next day, we didn't hear anything about it on the news. Also living on 17th Street at 341 17th Street, there was a murder across the street, never made the news. At that time, the Fox restaurant was in Atlantic Station, and there were several armed robberies where people went in with guns while people were seated eating, and they ran through our apartment complexes committing crimes. We never saw any of that on the news. This bill will put an end to big apartment complex building companies putting a stifle on the news or whatever it is that they do to keep the general public from knowing about these things happening. This bill will stop that. They shouldn't do that to the residents of Georgia because they have more money and they're already taking advantage of the state, and they're taking advantage of the residents by not providing the right protections, maybe by lighting or what have you, or letting the wrong element on their property and putting our loved ones, our family, our children in jeopardy. I'm a single parent of one adult daughter. I would hate for someone living next to us and we don't know that this person just committed a malicious act against a child, and my daughter's just running through the hallway, or my nieces and nephew came to visit me and I don't know, that they've just came in contact with somebody who committed a serious crime against children. That would seriously bother me. So please, let's get this out of committee so that it'll have a chance this session. Thank you, Chairman.
Thank you, Ms. Furby. So I know that Rules Committee is beginning at 11, and some of the members have had to go to Rules Committee, the members who have been leaving, but I would like to continue. We were scheduled to end this meeting at 11 today, but I want us to keep pushing on at this point in time. So I appreciate our members who are with us online so that we can maintain a quorum to consider this bill. All right. Any questions for members of the committee for Mr. Chapman or Ms. Furby? All right, hearing none. Thank you so much for being here. All right, our final witness that we have signed up is Emily Hurst, who's joining us online, I believe.
Yes, that's correct.
Yes, we'll hear from you. Thank you, Ms. Hurst.
Thank you very much, and good morning, Chairman and members of the committee. My name's Emily Hurst. I'm here today on behalf of the Georgia Municipal Association to speak to this bill. Thank you for the opportunity to speak today. We'd like to thank the author for bringing this bill, as we are most certainly aligned in wanting to keep our citizens safe. However, GMA does have some concerns with the bill that we would like to bring to your attention. The first issue that we see is the new administrative burden that this will impose on our police departments, especially the small ones, requiring our police to geofence the list of crimes provided in this bill, which are included by name rather than their location in the code, to specific applicable apartment buildings is not a small task, and one which will take our officers away from their regular duties. Secondly, we're concerned about what liability this bill might impose upon our cities if an error is made in the process. Say, if a crime is attributed to the wrong apartment building, would the incorrectly maligned apartment building owner try to sue the city? Or would the residents of the apartment building where the crime did in fact take place try to sue the city? Additionally, how would the requirements of this bill intersect with the provisions of OCGA 367430, which prohibits cities from keeping a registry of residential rental properties? Even if the city's immunity would remain in effect, we're concerned that this might still result in confusion and unnecessary litigation at cost to the taxpayer. Lastly, we would respectfully suggest that the committee consider providing an exemption to the requirements of this bill for those police departments that have 10 or fewer full-time officers, as such small police departments could really struggle to meet the requirements of this bill. Yes, indeed, we have spoken with Representative Maynor and we've shared these concerns with her. However, unfortunately, we just don't see a way to effectively implement this bill in this current format. And at present, we don't have any specific language that would be able to resolve those issues. However, we are happy to work with the author during the off-season to try and find a solution.
Any questions for Ms. Hurst? All right, hearing none. To the sponsor, any response you'd like to give?
Yes. So when I did speak to Ms. Hurst, I was amenable to changing it to exempt law enforcement agencies with 10 or less employees to accommodate. But I also want to say something else that Sheriff Labatt told me is the FBI UCR, Uniform Code Reporting. I hope I'm saying that right. Would essentially ease the burden of getting the data. And I also want to just bring up, there are several, if you look online, if you did a search for online crime reporting, there are several entities that are doing this that can help with the process, including the Bureau of Justice Statistics. They already have arrest data analysis tools. They have correction statistical analysis tools, easy access to juvenile justice prevention tools, federal criminal case processing statistics, NCVS victimization analysis tool. That's from the Bureau of Justice Statistics. Then there is LexisNexis has a community crime map. All police departments have to do, according to this website, that is nationally used, is link their system up to this. And at the very end, it says, contact the public information officer in your city to request that they start sharing crime information with you through Community Crime Map. It's absolutely free for your city to participate. Another website is from the FBI, and they have links where they have a program called Crime Data Explorer. So law enforcement agencies can link their data to the FBI's Crime Data Explorer page and easily have the information available. I would also just like to say it's 2021, and in an effort to save trees, many agencies are going to online tools. So I think that this is helpful for the state of Georgia.
Representative Maynard, I know this wasn't all of the issues that were raised by Ms. Hurst, but as far as the applicability only to law enforcement agencies with more than 10 law enforcement officers, did I hear you say you were agreeable to a provision along those lines to ensure that we don't have maybe some rural, very small law enforcement agencies that are captured by this?
I am, yes.
Okay. One possible amendment then would be, if it's acceptable to you, but it would read, as inserted by Legislative Council after line 26, this code section shall not apply to any county or municipal law enforcement agency employing less than 10 full-time or part-time certified law enforcement officers. Would that be agreeable to you?
I think that's very agreeable.
Okay. Are any final questions for the sponsor or Ms. Hurst while she is still with us? All right, hearing none. Thank you very much. So the bill is now before the committee. If there's a motion, I'd be happy to hear one.
Motion do pass.
Motion do pass from Representative Dreyer, second from Representative Wilson. All right, there's an amendment that was just discussed, the friendly amendment after line 27, insert, this code section shall not apply to any county or municipal law enforcement agency employing less than 10 full-time or part-time certified law enforcement officers. Is there a motion for that amendment?
Motion do pass.
All right, there's a motion for the amendment from Representative Dreyer. Mr. Tolbert, have you had sufficient time to hear the amendment?
Yes, it sounds okay. I didn't capture, I didn't have a chance to write it all down, so I do need a copy of it, but it sounds okay.
And if it's all right with the committee, we'll just give Mr. Tolbert some latitude to adjust as necessary for the final substitute that comes out.
Okay, thank you.
All right, motion on the amendment from Representative Dreyer. Is there a second to the amendment? All right, a second from Representative Wilson. Any objection to the amendment? Hearing none, it's adopted. All right, at this point in time, we'll consider the bill. Any further discussion from committee members or proposed amendments? Hearing none, we'll consider the committee substitute to House Bill 138, LC 413058S with the change that's been made here in committee as part of this committee substitute. All those in favor signify by saying aye.
Aye.
Any opposed? All right, the bill passes. It's on to rules. Representative, if you wouldn't mind filling out a rules committee form here so that I can sign it so that you're able to submit that to the rules committee. Thank you so much. All right, we're adjourned. Thank you.